Greetings, one and all, and welcome to day 2 of the 6th Virtual International Summer School on Mediation by Nivaran, Mediators of Supreme Court of India, in collaboration with the Singapore International Mediation Centre, the SIMC, and the Commonwealth Lawyers Association, CLA. I, Sakshi Banga, am your host for the day. I am a mediator, accredited with and an advocate at the Supreme Court of India. I have donned the hat of a mediator only for the last 2 years, and I have found it to be a very fulfilling and enriching experience. I would go as far as to say that I have become a better person because of it. During the opening ceremony on the 31st of July, our Honorable Chief Justice of India, Justice B.R. Gavai, rightly said that mediation is not just another skill, but a life skill. And Ms. Shireen Khajuria rightly summed up that thought by saying that mediation is a mindset, and I feel we as mediators are all better for it. I would again go as far as to say that it even makes us better lawyers. At the outset, I would like to welcome all our 500 plus participants and request everyone in attendance to please put your questions in the chat box, and we will take them up at the end of the presentation in the question and answer session, which will be for about 20 minutes. Yesterday, that is on day 1, we had Ms. Diana Sunaba Dapa, the former Deputy Attorney General and Minister for Justice Ghana, speak on the historical perspective and give us an introduction to mediation. Our topic for today is online mediation, its advantages and disadvantages. And our guest speaker for today is Mr. Jitendra Mohan Sharma, Senior Advocate and Mediator, Supreme Court of India. We welcome you, sir. A little bit about Mr. J.M. Sharma. Sir is a practicing senior advocate in the Supreme Court of India for the last 30 years and is an accredited mediator of the Supreme Court Mediation Centre and has been attached with the centre since 2009. He did his mediation training from Harvard Law School in 2008, as also from the Singapore International Arbitration Centre. Sir has been referred cases by the Supreme Court independently as well as by the Supreme Court Mediation Centre. As a mediator, he has facilitated parties to settle their commercial, matrimonial, family disputes, and criminal matters. Sir will be speaking on our topic for the day, which is online mediation and its advantages and disadvantages. Online mediation is also known as virtual mediation, and it has been in practice for a few years now, especially the past 4 to 5 years since our country and the world was impacted by the COVID-19 pandemic. And it is now a widely and commonly accepted mode and practice of dispute resolution through the process of mediation, making use of technology and internet-based platforms to conquer and bridge the gap brought about by physical distance, ill health, disparity, and destitution, which make in-person appearances difficult. The mediation sessions are conducted through video or teleconferencing technology. In the opening ceremony of this summer school, held on the 31st of July, Mr. Santana Krishnan spoke of being introduced to Zoom technology during the pandemic and the fact that Nivaran has conducted more than 100 programs online virtually very successfully, and the fact that online mediation can be equally successful. Sir also gave the example of the planet Earth being one and without boundaries. It can be said that virtual mediation is a huge step towards a planet without boundaries, giving us access to one another in dispute resolution across all boundaries. We have over 500 people in attendance today, and the only infrastructure that is needed is technology to connect us all to this one platform. The advantages of online mediation are many. It is convenient, affords immense flexibility, and is more affordable and accessible to people. It offers a no-contact environment, allows people to attend the sessions from familiar surroundings, that is the comfort of their home, office, or any other such space. In contradistinction, it comes with its own set of challenges, a few of which are privacy and confidentiality issues, less or no control of the mediator over the physical environment of the participants, and the complete reliance on functioning technology and stable internet connections. There is reduced personal connection, and it becomes difficult to pick up on non-verbal cues. Cultural and time zone differences and distractions are other challenges that need to be navigated. Our guest speaker for today will speak and elaborate on our subject for the day. Over to you, sir, Mr. Jitendra Mohan Sharma.
Thank you, Sakshi. Thank you so much. Thank you for a nice introduction and for such kind words. In fact, to begin with, mediation, all of you are aware of the mediation school. This school has been going on a mediation. And for mediation, a communication and interaction is a way, which is a USP, to have facilitate a settlement. And online mediation, as a form of online dispute resolution, has become a global movement. It is increasingly actively developed as a form of mediation flexibility. It is believed to increase the effectiveness and efficiency of alternative dispute resolution through the use of technology as the purpose of an online dispute resolution itself. Today, I would just like to interact with you and indicate how online mediation is beneficial and good, and its technology can be used. One thing is for sure, that technology has brought new things together. Absolutely, at communication level, it has brought a revolutionized. Possibly a generation of 30 or 40 years back, they possibly would have found it a little difficult to communicate in this manner, this technology. But this technology has gone a great far end. Now, as far as the mediation is concerned, I would be initially emphasizing on the Indian scenario, how the mediation evolved, online mediation, and thereafter an online mediation in India. The mediation is a, can I have this? Yes, slide is there. Yes. Mediation, for the first time, though as a word mediation is culturally inbuilt in the Indian ethos, the Indian subcontinent. Otherwise, also it was there. But the mediation for the first time came in 1999 Amendment Act, Civil Procedure Amendment Act. This is Procedure for Civil Court. And Section 89 was introduced, and that indicates an alternative dispute resolution, where the Section 89, which recognized mediation only as a alternative dispute resolution mechanism. In 2005, there was Supreme Court, there was no statute as such, but the Supreme Court on its own created a Mediation and Conciliation Project Committee, and it was constituted in 2005. Now in 2005, for the first time, Mediation and Conciliation Committee, Project Committee, which we call it MCPC, it emphasized the need of a communication in a mediation, and communication, it was referred to in that it could be through a technology. So in way back in 2005, when it was not so prevalent mode, the Mediation and Conciliation Project Committee found that mediation can also be happen through a transmission, through a computer, or through an internet, which was not at that time so much prevalent. In 2023 in India, a Mediation Act came, and in Mediation Act, it defines a mediation process as to make online mediation as acceptable and cost-effective process, and for matters connected herewith for incremental thereto. Section 3 defines mediation, Section 3Q online mediation, and 33 defines rules to preserve sanctity. Now, as far as rules to preserve sanctity is concerned, they are still to be notified. So that on a statutory level, the rules of online mediation are still not yet in line. I have searched at the end of it. I'll just share with you the other judiciary where other systems where online rules are there around the world. But in India, it is still the rules for online mediations are still not yet there. However, this online mediation is in consonance with the UNCITRAL system, where the UNCITRAL has already defined as a mechanism to resolving a dispute through an electronic communication. May I have a next slide? Now, for an online mediation, the process is very important. unlike a mediation where you are having the parties interacting each other, here you're only through a communication, and communication through one-way transaction where one is speaking. The communication is you are receiving the information from other also, but there is a limitation that communication is through technology only, not what you have in actual communication where you're sitting across it. So therefore, in a mediation, what is an opening statement plays an important role. In online mediation, the opening statement plays a little greater role, because that's the first process, first time where the mediator interacts with the parties. While I just share you that whenever there is an opening statement, of course, you have to concentrate on neutrality, confidentiality, there is a no risk, and it's a consensual, that's a party-centric, and all those things. But just a few things, say like if the mediation is between the parties where the relationship is important, say like there is a family dispute, or there is a family matrimonial, or a custody of children, there pay a little more emphasis on the process of mediation. They say, because that will bring parties into a confidence with the mediation process, because that's the only way parties will be introducing you to the mediation process. Say like if there is a case, commercial mediation, where there is a insurance and a commercial, possibly in such matters, lawyers are there. Parties are even at times represented by lawyers only. So you can, lawyers are possibly aware of it. And there is a labor or employer-employee dispute. There you have to make sure that two things have to be, the opening statement plays a little greater role. So A, you have to address your neutrality as a mediator, that the mediator is a neutralist, and the confidentiality. The confidentiality, which is otherwise in a main one-to-one interaction, in online dispute, it plays a little role, and it has got its own limitations. Say like whenever there is a confidentiality, you have to make it very specifically and clear that the proceedings which are being held in this mediation will be absolutely confidential. No one will like to record it. No one will use it. And at times, whenever there are centers are there, so centers do play an undertaking. Whenever do a private mediations, we always go for an undertaking which says that you are safeguarded, that this will not be used, these proceedings will not be used elsewhere. Then you comes the transparent mechanism. The transparent mechanism, the more transparent you are, say like at the very onset, when you're saying as a mediator, when you start with an opening statement, you say, we'll be having a separate session and a joint session. After joint session, you go for a separate session, each and individual. The joint session becomes a little more important in a online mediation, because here you are understanding both the parties. While in a separate session, caucus, there will be a more interaction with an individual party. So what possibly at times I have experienced it. I put it a day by day. Say like a joint session is in the first one, and then I say, yes, sir, now I'll be having a separate session with party A. Possibly, or next day I'll put it this way if parties are differently. In fact, in Supreme Court, the mediation is online more prevalent, because the parties are living far away. Rarely you will find that they are close by living, and the parties, they do come. I'm not saying that they're not come, but online is equally important, and plays an important role, because parties are coming from a far distant places. There are parties from deep south, or Far East or North or parties living abroad. So the mechanism has to be a transparent one. You must indicate that I'll be having a separate session on this day. What we normally do is create a group in which all parties are there. Then you can have, today I have a session with A party, and from this time to this time, and have a second, on this date, I had a session with that party. So explain that in clearly that there is a transparent manner. And whatever the proceedings do take place, do write down in the group, so that every party, though he is not having a session with you, but possibly he was having a not having session with you, but he knows what had happened. Then the third important, the process would be the principle which we have to follow it. There is an equality of position of the parties. At times, there are some people are very comfortable with the technology. Some people are not so comfortable. Some people are camera shy. Some people are not so. So you have to, as a mediator, you have to follow it. That you have to identify who is ever finding it a little weaker party, a little unequal position, and you have to balance it. You have to empower the party, and you make sure the parties that there is a protection, that there is an apparently there is a absolutely transparent mechanism in this point. There is a confidentiality. So you have to build up confidence in that process at the opening session. And the most important at this opening would be that you say, in case a settlement is arrived at, it will be in accordance with law. And the settlement would be arrived at. If it is through court annexed mediation, then the settlement would be sent to the court, and there will be court or will pass an order. Or if it is a private one, now under the the Mediation Act 2023, private mediation has also been recognized. So the mediation settlement can be recognized, just like an arbitration award under 1996 Act. So you have to, in the very beginning, this things have to be made clear. Maybe the next slide. Look, this mediation, online mediation, is based on internet. It is internet based. So therefore, the first and foremost requirement for a good online mediation is that you must have a technologically good internet connection, have a good the system where you can interact through video or through audio. And as parties say, you can go for a Google Meet, you can go for a Cisco, you can go for a WebEx, or you can go for a Zoom. You can ask parties. This is another thing which I must tell you. I always ask parties to give their internal write-ups, whatever their writes up, through email. And I ask separately, not in the group. Whatever is a joint session, that they can always communicate in the group. But whenever they want to give some calculation or some particular what they had in a caucus, some calculation or some other relationship or some document, I always say, please give me on email, and I keep separate email. Now, Supreme Court Mediation Center has its own specialized form. There's a platform. They've got a website, and there is a system which takes care of the center. Now, there could be, this new act has provided pre-litigation mediation also. There could be, now there will be in India also, outside India, there were still prevalent in that sense. But in India also, you as a lawyer, as a mediator individually, there could be cases where the private parties come to you and they say, sir, please, before we go for a litigation, please help us and do mediation. So I would suggest that before going for it, and that's an online mediation. That's an online mediation. So therefore, I would suggest, first of all, have an undertaking. An undertaking that should be in writing, keep it with you in writing. That should be the digital signatures, or it should be signed and then sent to you, a scanned copy. But keep that with you. And this undertaking would indicate that the mediation talks would remain confidential. That's very important. The Supreme Court Mediation Center do ask that this process would not be used elsewhere. I would not use it on any social platform, or because this is the one thing which is there. In undertaking, you must involve this. If this would not be used elsewhere, apart from confidential, I would not use it in any social platform or elsewhere, or the photographs or naked giveaway. That undertaking has to be there. So please do take that undertaking. That's important. Yes. Now, after online, after start going through the opening session, now as a mediator, it is your responsibility as a mediator to communicate. Communication is the USP of a mediation. Unlike in a process of adjudication where the other things are also there, here the communication is very important. Now the communication is not just like talking, interacting, or listening to somebody, or what the parties say, just I listen, I'll just talking. It's an interacting, but it has to convey a message. The interaction has to be a focused one. That focused interaction would be that you are identifying obstacles by gathering information. You are collecting information from them, from the parties. And for you as a mediator, you can always note down on your own whatever you feel like. It's that online mediation is for communication, but always keep a writing for you, so that next time whenever you go, you can always take a cue from thereafter and identify the issues. Identifying an issue online is comparatively comfortable, unlike in a other one-to-one interaction. When you are in one-to-one interaction, the parties interact in so many other things. While you are on online communication, the parties would like to give you less information and the focused information. Otherwise, information are always curtailed. You are an anchor of that communication. So you always put questions, focus those questions, asking and gathering information. And the second, maintaining control over the process. This is very important. At least when you are in joint session, you should not give an impression while you are interacting with one party, because other party is there, that you are giving some favor, some bias, or showing some favoritism, or some is stronger party, or there is a weaker party. Some party may feel a little alienated or a little out of place. So you have to control it. If somebody is speaking a little more, at times where the mediation is regard to relationship, there is a family mediation, or a matrimonial. There are parties have got some issues to say. So therefore, in a joint session, you just control the process and draw a line. When you feel that it is going out, just say, let us reserve this for a separate session. In a separate session, you can have a full interaction, whatever the party want to say, because parties has to already, whatever you want to say, he must feel that he has been heard. The mediation has got another great USP is that the parties, since it's a party centric, so therefore the party must feel that he has been heard. Once because in an adjudicatory process, possibly he always has one thing, that his communication is through a intermediary that's a lawyer, and through a court. Rarely at times he has a direct interaction with the court, or that is all through an intermediary. It's in mediation only that he has a communication directly of his problem. So therefore, have an effective interaction with the parties, and the separate session have a separate ask them to have a more interaction, and whatever the burning issues are there, you can always help them. May I have the next slide? The advantages of an online mediation. It's very simple and flexible. It can be so simple process, because as the communication is there, I'm interacting with you, things are there, and system has to be followed in a systematic manner. So it's a flexible. The time limit is you can have it any time. You can have it parties. Say like at times whenever there are parties belong, I have a mediation with one of the parties in UK or US, the other party is in India. There is a time gap. So I always ask them to have it on morning or in evening. Or at times the party says, sir, I cannot interact on weekdays. Can I have I have an office. Can I have it about evening, 8 o'clock or 7 o'clock? So that's a flexibility. Unlike a real mediation where you say, no, you have to come within 9 to 5 or a little more at a center. Then the party has to come. The traveling is there. The party, suppose it's a close by, even then he has to travel. So that's an advantage in this process. It's simple and it's flexible. Not much paraphernalia is required. You can have it. Then while you are interacting, you can ask parties what are the options in a separate session. You can have what could be the solution to this problem, and it could be much more effective. Then there is a time flexibility, as I said, control and individual sessions. Now this individual, as I put you this earlier also I said it, individual sessions are very important. So in regular mediation also they are important, but in online mediation, you have full time. Full time in the sense you can always interact with the party. And unlike a real mediation, in online mediation, parties will always be a focused one. This is my experience. The only thing is you have to regulate them. You have to channelize them. Parties don't just talk. If you go for a one-to-one mediation, in a relationship, parties go for this thing, you don't allow them to speak. But in online mediation, my experience is by and large, parties are focused. And at least in commercial mediation, they are absolutely focused. Absolutely focused. They know what they want, what they do not want. So that online mediation really helps them and control the flexibility. The next slide. Now, everything is not so good, and there are some glitches also. One of the things which is the greatest, we find it, there is a technical glitch. Communication and this technical know-how, it is becoming quite popular. But even then, there is a communication glitches are there. But that communication glitches are mainly because of an internet connection. And internet connection is either by the private service providers, and gradually the services are being improved. As you see, the 4G was there. Now the 5G is coming up. Technically, it is also being advanced. Earlier, I recollect about 7 years, 8 years back, whenever rarely we used to have it, this communication. We used to avoid virtual. We used to say, let's have an audio only. And let's have the system was not so strong. But now it is there. Next is, there is a digitally limited access. all areas, India is a huge, I'm speaking of India at present, and throughout the world, there are other parts of the world also where there is digitally it's a limited access, or the digital is not so good connection. So that access is there in India also, though service providers are there, but there are certain regions where there is a limited access. But whenever there is a digital access is not there, then it's wonderful. The next is the communication barriers. As far as the communication, interacting with the parties identifying the issues, mediator helping identifying the issues, what was their problem, and the parties themselves through communication would give a suggestion, possible resolution, how it could be resolved. That can happen only through a communication by a mediator. So the communication is the greatest USP of mediation. And a mediator has to have a good communicator. Now in mediation, while you're having a one-to-one, there are a lot of modes of communication. While in digital, you are only having a virtually, you are seeing, you are hearing, and that's all. The body language, comparatively, the non-verbal cues are comparatively not there. The body language of the parties, how the parties are comfortable with the new technology. At times, they are little hurdle, but this can also be overcome. Some parties are not very comfortable with the technology, and there is a reduced personal connection. Third is that there is an enforcement of security of personal data. In any case, all these conversations, the commercial parties do find it whenever there are parties, they say, okay, sir, our data will be taken by the service provider. So as a file, I found it to be, of course, that's depending on individual case to case. We did at times FaceTime or from an Apple. Apple still considered to be comparatively safer. I'm no expert on that which is the much more safer, or the Zoom is much safer or so. But still, that is there. So I interacted with, in some cases, on a FaceTime by iPad, iPhone, which is comparatively safer. So, but you must, as a mediator, you must be concerned with somebody, for the party, that there is a security for their personal data. As far as the time zones are concerned, there are different time zones. And the next is very important. There is an execution of settlement agreement. At times, the parties are living poles apart, different places. Now, how it could be signed? One, it could be a digital signature. If the parties are comfortable, we'll have a digital signature and settlement is with you. One of the things which I just share with you, my experience, that there was a settlement, an online settlement was there. So thereafter, I asked the parties, the councils, I made councils. One of the party was living in Calcutta and the other was in Hyderabad. Sorry, Hyderabad was another settlement. Both parties were in Calcutta, but they were a little different. I asked the lawyers. I drafted the settlement. I said, please take out a print, and after on print, get signed. Keep that settlement in your custody. Put your signature so that one party and his counsel signed. Then both lawyers took the responsibility. Got the sign with other party, and they returned back. And it was sent to me through lawyers only, those who are advocate on records. So I had a party signed at local place, second party signed at local place, sent through advocate on record, and thereafter I signed it and send it to the court. In Hyderabad, why I was mixing it, or in Hyderabad, the parties were living little away. But in that case, whenever a settlement arises, you can always bank upon lawyers. Take lawyers into confidence, ask them, and take both lawyers. Never take one lawyer. Ask both lawyers. That is your responsibility to get the signatures done, and make sure they are there, and you countersign it. So this is a thing which can be done. If parties are from abroad, I always ask to have a digital signature, or ask them to execute a power of attorney or an authorization and send it to the other party. If other party says yes, it is okay, the authorized person can sign it. Then authorized person, then his identity, all are attached with the settlement, so that tomorrow somebody may not say with regard to settlement. Yes, may I have the next slide? Now, just a few explore. Singapore has a CGTS, that's a Singapore Community Justice and Tribunal System. They have got an online rules, and which they say, which by and large, which I have covered in this talk specifically, I'm not taking it. So among the Commonwealth countries, this is the one which is there by and large, which is prevalent in Singapore. The other thing, which for a European thing, I thought of a Spain. That's an act on mediation in civil and commercial matters in 2013. But in 2013, that was an act to resolve the disputes. And thereafter, online came in a little later on. About Singapore, I just like one more thing. What interesting thing which they did it, they said specifically the smaller disputes, which possibly other jurisdictions may also take it, for a smaller disputes, say like a consumer dispute of a not a larger amount, say like amount to up to $5,000 US, or a I'm using a word $5,000 for a understanding for a common one, or a 5,000 pounds or so, like it. That can be done through the commercial one. That should be done only through mediation, online mediation. And in commercial, my experiences in commercial and otherwise mediation, this online mediation is really good. USA has a state-wise online disputes, otherwise, because US is the federal system, it has got a different disputes. Different states have got so, but by and large on the same principle. And so this smaller claims in India can always be gone through on a virtual one. Yes, thank you. Thank you for giving us such a patient hearing. Yes, Sakshi.
Thank you, sir, for a very enriching discourse. You have beautifully traced the entire process of mediation with specific focus on online mediation sessions and the immense importance of undertakings as well in online mediations. Very importantly, parties are more focused on identifying issues, you said, in online mediation, which always makes a mediation process more effective and expedites the solution. It was especially enriching for me to learn about the online mediation systems around the world. Thank you very much. We will now take questions from the participants from the chat box. We have one question from Ms. Ruma Pathak, who says, mediation through online mode or offline mode, which one is more effective?
Ruma, interesting question. It is just like it. Somebody for particular, you can't say identify specify. Okay, for this one is only online. For this one, it is an offline. But definitely in commercial mediations, online can always be a little more focused. But in family litigations, family disputes, online has an effect, has got its own force. But having a offline mediation where there is more air to be vented out, then offline would be still go for thing. But definitely it all depends on the parties. Say like parties are far away living far away, distant places, they say, sorry, sir, we can't come, or I can come, he cannot come. So all those logistical problems are there. So in those cases, online mediation is the only way out. So you can't just give a one shot for this would be better, but definitely mediator has to take his own call.
The next question, sir, is from Ms. Lenny Rahman, who says, how many mediation sessions, full day or half day, would the court afford for court-annexed mediations?
Look, for court-annexed mediation, the court, normally the practice in Supreme Court is when the first mediation court orders. In Supreme Court, whenever Supreme Court orders that the parties are referred to a mediation, they gave an option on the first day. The court order specifies that either the parties can have a virtual meeting, that's an online mediation, or it could be a physical, but can have it in the Supreme Court Mediation Center. So it all depends. The center takes care of that. Logistics problems are taken care by the center. The center communicates with the parties and their lawyers and asks them, would you like to come physically, or would you like to join virtually? At times, both parties say, sir, we'll join virtually. The first session, at least joint session, would be virtual one, so that parties may come to know about what the process is going to happen. Or at times the parties say, okay, since we are very close by, we can come. Or one party says, I want to join, I can come, but I cannot. The other party says, I cannot come. So it all depends on individual. As far as your time is concerned, individual sessions are concerned, how much time one can take? The first session is there. If the joint session continues and the parties say yes, and the mediator feels that there is a possibility of a settlement, then rest assured, my take is that the sessions should continue, maybe taking an hour, maybe taking another 2 hours. At times we have come across that mediation settlements. There are experiences where mediators have settled at 11 o'clock or 12 o'clock. And even center was saying, sir, we have to close center because there is a Supreme Court is in the security zone. So therefore, the security people were asking, sir, please close it. But since the parties had come from a distant place, we asked them to complete the session. So therefore, time is not the limit. So that's not the constraint. And as a mediator, one must continue.
Rightly said, sir. The next question is from Ms. Mehak Gupta, who had asked a wonderful question yesterday as well. And her question is that with online mediation becoming more prevalent, especially after COVID-19, do you think party autonomy is enhanced or diluted in a virtual setting? And how can we ensure that parties retain meaningful control over both the process and the outcome in such digital environment?
Heck, very good question. One I must make very clear, the mediation is a process where there is a party-centric. It's a party-centric. That's the first party-centric. But at times when there is an online mediation, at times the party says, possibly feels that she or he is not so comfortable in digital communication. So therefore somebody else is communicating. Or when there is a there is a physical meeting, then the counsels are more interacting or somebody else is interacting. Now here the mediator has to take a call. The mediator has to find and to take a call to allow it to have a more party-centric. The more party, if it is more party-centric, then the solution will become comparatively easier, because the party would come out on its own with some of the inbuilt, the facts he will narrate, those facts narration will have an inbuilt solution. Definitely after COVID or during COVID, it's an absolutely, of course, COVID had got some other effects also, which are fatal and otherwise the bad. But the one of the things which has happened that it has revolutionized this digital system. The digital system throughout the world, it is revolutionized. And they say that the communication through digital means have increased manyfold. Say like, even you said in the beginning, I just share you this, this about 6 years back, Nivaran started one session, a physical one, and then the COVID happened, we stopped. And then we started using digitally. Now our communication is more than 100 sessions we have taken, and just because of this technology. So technology has to be taken care of, and rest assured, as a mediator also, allow party to interact as far as possible. Have an interaction more with party. Whenever there is a private session, just ask everybody to join, no problem. Don't hesitate in bringing, saying, sir, you don't join. Ask anybody to join. At times, you will find an interesting thing in a family matter or so, in a relationship matter, either matrimonial or a family dispute. There are some persons who are sitting side by and they are prompting. Just politely say, next time, sir, everybody, if you want to add your father, give suggestion from your side. If you want to add your father or so, or your somebody friend who want to join, please allow him to join. After joining, what you can do as a mediator, you can always say, sir, it's very good. Thank you very much that you have come. But since we are interacting more with the party, so I would concentrate more interaction with the party. But as a lawyer or as a friend, you must be aware of it. Keep on give them suggestions. But I will be focusing interaction with them. So that's how you interact with the parties and you communicate with them.
Mr. Ron Collins asks, have you ever had the experience of failure of the platform during mediation at a time when the process was going very well? If so, how were you able to move forward?
Failure means the technological failure, or?
That's right, sir. Of the platform, yes.
Look, that's a little dicey, absolutely right. That it brings a little pause, but it is just a pause. And thereafter, either we put it audio on through a communication. That's why I said, if we form a group, and group is through a mobile system. And in that group, we can always say, today we are having an interactive session with A party. Suppose I am having an interactive session with A. So that A session, the technology fails. There is no VC or a virtual session. So in the group, I'll just put it this way. Sorry, sir. That's a second line of communication. That's a backup planning. The group always works as a backup plan. While the main interaction is the virtual session which you are having the party, but the group is always a second, where you can always say, sir, today it is a technical failure. It happened in that way. We'll have it afterwards. Or I had some problem or some otherwise problem. So always form a group. And group has got two advantages. A, in that group, everybody will come to know what's happening. You don't have to run after A party or a B party. You put your communication in that, and I found it to be very useful. So whenever you are having a session or so, but pause definitely at that time, that is a little hampered, but it's a pause only, and that you move on.
Ms. Ria Chug says, in the context of online mediation, one of the major concerns is maintaining the privacy and confidentiality of the parties involved. At the same time, the virtual nature of the process often creates communication barriers, especially when the parties are not comfortable with technology or when non-verbal cues are lost. So her question is, how can mediators, I beg your pardon, effectively address these challenges and ensure that the mediation remains both secure and smooth in an online setting?
Very good question. And rather, the whole mediation process is based on very good question. Who is asking the question?
Ms. Ria Chug.
Ria, it's a wonderful question, because the whole online mediation process rests upon these questions which you have asked for. Confidentiality is one of the most important things in mediation, whether it is an offline or a inline. Now, how to handle that online if it is an online mediation? The joint session, I would just what I do on a normal I suggest is, if I would have policy, Joint session would be a smaller after the opening session and have a first hand of the common joint facts. And thereafter, I'll immediately spill into separate session. Now, first, I will have before that, if it is a center through court annex mediation or a private. If it is a court annex mediation, the center itself takes care of that undertaking that it will not I will not use this communication elsewhere. But if it is a pre-litigation or a private litigation, private mediation, and as an individual you are doing it, always prepare an undertaking. That undertaking indicates I will keep this proceedings as a confidential. I will not use it elsewhere. I will not use it in a court of law. I will not use it in any social media. I give an undertaking and keep those undertakings signed by both the parties along with their lawyers, if their lawyers are represented. Then always have a separate session. I will not record also, all that undertaking would indicate that way. And then in your opening session, emphasize on confidentiality. That confidential is very, very important. Third thing, when you are having, always have a separate sessions. Separate sessions, if the digital platform permits you, you can have a session. Then the other party can be in waiting or not connected, or then you can have I normally do it. What I practice is, I have in the group, I say, I want to have a session with a party for half an hour and ask the second party, okay, please sir, log out. And then I'll have a session at after 20 minutes or put in the group, I will have a separate session. So confidentiality, so that the other party may not come to know about it, separate session. And at times I found it to be working because the parties are more confident and they interact. And they more openly comment when they are assured that my communication with the mediator is absolutely between me and mediator, not anywhere else. Normally, I ask somebody who is confident, close to party. Say, like if party's lawyer is there, I always ask the lawyer to be in that private session. Or if there is a relationship, somebody is there, her friend or his friend or lawyer, some local lawyer, but always take services of a lawyer. Don't feel that lawyer is, things are fast improving and lawyer services are always advisable, because at least you can communicate in India, you can communicate with lawyer. There are some earlier experiences that were not so good. Initially, when in 2009, when we started, there were some resistance. But gradually, as we are becoming aware of more mediation process, the lawyers are equally participating and they are becoming more enthusiastic. So keep lawyer in loop so the confidentiality can be met.
The next question is from Ms. Abha Sharma, and she asks, how can the mediator ensure that both parties are fully present and they are not being coached? And also how to read body language during online session.
Look, coaching, as far as that part is concerned, that's an interesting, in the sense, coaching in an offline mediation, it could be a tutoring. The party can be tutored. But in coaching, you will definitely come to know that mediator has to ask such questions in such a narration. And thereafter, one more thing which I just suggested in an earlier question also, I said, if there is some, you feel like that there is an interaction, somebody is prompting or so, you can always say at the end of the session, without making it, if you want somebody to be there with you or your friend, you feel not feeling comfortable, or your lawyer or anybody, please ask him to join. And when they join, then they say, sir, very good you have joined. I'm thankful, grateful to you that you have joined. But I'm interacting more with individual party. And so I'll communicate with her only. You add your inputs or your values. This cue, this suggestion or this statement will give a cue to somebody, to the one who is prompting or so, or he will give his one value. it all depends. Why this way? That always a negative one. At times they are helpful also. The friends are always, at times they are helpful also. But allow them to, normally in a relationship, these things happen in moral relationships. In a commercial disputes, these things doesn't happen much in a much way, because their things are more from a commercial perspective. The party is saying, I get a compensation. If I get this way, I get an X amount of compensation. If I don't do it this way, I may get X plus. So I must negotiate with X plus so that at least my X would be there. So there are no emotions. These things happen whenever there is a family relationship. So for a family relationship, always allow party to, first of all, vent their feelings so that they may have a first satisfaction that they have been heard. Give them that satisfaction that they have been heard. Unless they have, parties are having a satisfaction that they have been heard, they will not come to a solution. They will themselves will not come out with a solution. As far as the body language is concerned, look, for online mediation, that's a little barrier, that you can't have a communication of other aspects which you have an advantage of in offline mediation. But that's a balancing factor. Say like parties cannot come, or you want to continue with the mediation, some mediation, or you can do a hybrid one. I can do a hybrid one. You can always say, this is also a thing where you feel like, okay, at least for this session you have to come. So do a hybrid session.
We have 5 more minutes for questions. We have several questions coming in. We will try to take as many as possible, and if not, hopefully answer them at a later date. Ms. Amira Rizvi says that at present, India does not have robust data privacy laws in place. However, one of the fundamental principles of effective mediation is the assurance of confidentiality, both in terms of the process and the identity of the parties involved. In the absence of strong data protection and mechanisms, the integrity and trustworthiness of the mediation process may be compromised. Her question is, what is your perspective on how this legal gap affects mediation practice, particularly in online? Also, what is your take on AI-assisted mediation for petty matters?
I'll start with the AI aspect, and then I'll go into. Look, that's a good suggestion, and AI suggested one, the Mediator. It's just like an online, but AI would replace as a mediator in petty matters that have not yet been experimented. Even in Western world, in US also, it has not been experimented, though they have been going for a driverless vehicle, but they have started in some places in US or elsewhere. They have started driverless vehicle, which can cope up with the traffic problems. But in legal system, as a mediator, AI for a mediator has not yet been substituted. But I still feel, this is my personal take. I cannot be judged from all point of view, from this perspective. AI has got its own limitation. AI responses to the fixed ones, and I'm not diluting that effect. But at times, you are dealing with human beings. All human beings don't behave in the same manner in the same situation. Each human beings, a class of human beings can behave in such a manner, but the human beings human behavior is affected by so many other factors. Economic, cultural background, economic aspect, what is his education, and so many other aspects. So AI cannot be substituted. However, as I put it, AI is there. For commercial, it can be. So I'm not undermining for relationship, the possibility AI cannot be substituted, but in commercial matters, AI can be substituted. There is an option. I'm open to that. Now, coming to the data privacy in India. Look, in India, the data privacy is still not there. The act is, there is no statutory provision, to my understanding, to my knowledge, it is still not there. But the data is always available with the service provider. The state government has to come up with a protection. Though in some Western countries, there is a Data Protection Act. But as far as the confidentiality is concerned, in India till now, Ms. Rizvi, what you have put it question, I put respond to that. In India till now, most of the mediations are court annexed mediation. So there already parties are in court. And now the court finds that there is a possibility of mediation and it sends to the mediation. Maybe High Court, maybe Supreme Court, maybe District Court or elsewhere. Few of the provisions do say that there has to be pre-litigation mediation. And new Mediation Act has already provided for pre-litigation mediation. And online rules are still not yet notified by Government of India. So under Section 30 of New Mediation Act, the new online rules have to be notified. So as and when it comes, possibly this data protection would possibly taken care of, and it should be, let us see what they're going on. So for the data protection, but that must be taken care of. As far as the identity of parties are concerned, since it's a court annexed mediation, the parties are already known. Therefore, that can be done.
Mr. Sanjeev Tripathi wants to know if it can be a mix of online and offline sessions in a particular mediation.
Yes, Sanjeev. Absolutely right. Absolutely right. It's an absolutely mediator's call. There is no hard and fast. Therefore, I just said it in an earlier question. I just responded to it. It's a mediator's call. If you feel like that, I want to have after having few online sessions, and a mediator considers that there is an impasse in the sessions, so you want to break that ice, call for parties for a physical session, he can call. And hybrid, at times it is effective, but it's absolutely an individual call. There can't be a hard and fast rule. At this time it should be taken, at this time it should not be taken. But it's a good suggestion. I would absolutely appreciate.
Thank you, sir, and participants, for this very thought-provoking question and answer session. As we draw towards the end of day 2 of the summer school on mediation, I would once again like to thank our guest speaker for the day, Mr. Jitendra Mohan Sharma, for the wonderful session on online mediation and its advantages and disadvantages. A study by the American Bar Association has found that parties who participated in online mediation were just as satisfied with the process as those who participated in traditional mediation. The study also found that online mediation was just as effective as traditional mediation in resolving disputes. This is, of course, in the American scenario. In India, traditional mediation and online mediation are now working in tandem to resolve disputes, and traditional mediation continues to be the preferred mode of mediating, with online mediation not far behind. The hybrid mode of mediation, I beg your pardon, which is a combination of sessions held physically at times and virtually at other times, or with one party and or their counsel present physically in the room with the mediator while the other party and or their counsel joins the session virtually, is more common in the present day. A mere and quick glance at the mediation cause list of the Supreme Court Mediation Center tells us that about 50% of the matters in mediation are being conducted virtually, online, or in hybrid mode, which in itself is very indicative of how far we have come in embracing online mediation in dispute resolution. As we have seen today during the very informative session of our guest speaker, Mr. J.M. Sharma, the benefits of virtual and online mediation are numerous, and despite the challenges it poses, which need careful management in the post-pandemic era that COVID-19 has shown us, online mediation has been universally embraced, initially out of necessity, and then because of its obvious advantages, ranging from increased flexibility and convenience to enhanced safety and comfort for participants, combined with recognition of its legal validity, which make it a powerful tool in the realm of dispute resolution and technology, and which has enabled mediators to connect parties in ways we never imagined even a few years ago. Online mediation is accessible to people of all abilities. Virtual and online mediation so clearly present a contemporary and innovative approach to resolving disputes, leveraging technology to overcome traditional barriers and foster communication between parties. As we continue to embrace technological advancements, online mediation stands at the forefront of progressive dispute resolution paradigms, offering immense potential to create a more equitable and accessible justice system in the digital age. So much so that even the 40-hour certification mediation training of the Supreme Court of India, as also Nivaran, is also now being imparted through an online mediation training portal under the aegis of NALSA, the National Legal Services Authority. Such is the power and reach, suitability and adaptability of technology that online mediation, with all due safeguards, is very much here to stay. With that, I thank you all for attending today's session. I also thank Rahul, Rohit, and Keshav for ensuring a seamless session. Tomorrow, on day 3, our guest speaker, Ms. Mia Forbes Piri, international mediator, facilitator, and coach in London, will be covering the topic Communication, Interpersonal Skills, the Path to Understanding. And the session will be hosted by Ms. Vinita Sahai. We start at 5 p.m. sharp tomorrow, and we look forward to each one of you participating. Please note that certificates will be given only to those participants who attend all the 10 sessions. All sessions are being recorded, and our tech team is very vigilant. So please do attend all the sessions. They are being held for your benefit. Thank you very much.